Good afternoon, everybody. We have a very strong attendee attendance today, this afternoon. I'm hoping that others will be joining rather rapidly now because we need to make a start. I hope you're all well, all those who are known to me and to others who are participating in this seminar. We hope you are all well and your families are well. It's been a long year in many respects, but on the other hand, it's remarkable how quickly it's gone. We are providing this webinar this afternoon. It's entitled Tips for Success. I will be leading the webinar in relation to promoting sites through the local plan process. And I will then be followed by Ashley Bowes, Wayne Beglan and Clare Parry, who are probably well known to you by now. The question and answer session will take place towards the end, once we've got over the presentations. And if you have any questions, please do raise your questions on the site. On the questions and answers box, please, rather than raising hands, because we've got quite a lot to get through. Now, I'm going to begin by dealing with the promotion of sites through the local plan process. Bearing in mind the title of this webinar, Tips for Success, the one thing one must be aware of, and for those of you who are experienced in the local plan process, whether as promoters or acting for promoters, or indeed acting for local authorities, is the need for cooperation between the private and the public sector. The success of a plan depends upon proper collaboration, and that collaboration must be founded upon very, very strong evidence base. And the best way to provide that evidence base is by working collaboratively. And I will make some points about that as we go through. Ashley, I wonder whether we might have the first slide, please. So, if you are a landowner or a promoter, you will be keeping aware through your database about emerging local plans, local plan reviews, and neighbourhood plans. You will need to have an idea as these plans emerge of what the housing and employment requirements are likely to be. You won't know precisely because, of course, those are matters which will be resolved through the various stages of the plan. But by Regulation 18 stage, there ought to be a very, very firm idea of what those requirements are. You need also to have regard to spatial constraints. What are they likely to be? And how might those constraints affect the viability of your site in terms of its appropriateness for development as part of a spatial strategy? And consider any evidence of what the likely spatial strategy is likely to be followed, and what alternatives exist. What are their respective merits? Because the Regulation 18 stage will be open, if you like, to consider those issues. And it may well be, actually, that in relation to one local authorities area, there might be more than one obvious spatial strategy that could be followed, depending upon infrastructure requirements and other constraints. And I put at the bottom of this, is there a likely need for a competitive strategy based on the spatial options available? And I put the word competitive in there because the success of a spatial strategy will depend upon the delivery of vital infrastructure. And it might well be that one strategy is more deliverable than another. There might even be instances where a hybrid approach might be taken. So it's at the Regulation 18 stage that the private sector can best engage with the local authority to explore those alternatives before they are set in stone. Ashley, could I have the next, please? Thank you. Now, this requires early engagement at officer level. There is no need to wait for the call for sites. You can actually start that process earlier on by engaging with local authorities if they have the personnel who are able to engage at that particular point in time. And it's helpful both for local authorities and also for the promoters to begin that early engagement, not only with officers, but also with parish councils and local individuals. That engagement is so essential because you want to gain the confidence of the local community and officers that what you are proposing is in their best interests. You don't want to be springing surprises and therefore alienating the local community whose engagement is so important at this early stage. Because the community response is something which will permeate the local plan process, both in its pre-examination stages and its examination stages. The engagement with officers and the community should be informed so that they can be engaged positively without being left with the impression that any proposals are fixed. And Ashley, could I have the next slide, please? Positive engagement is important. It means seeking the views of the community about the desirability of releasing the site for development. And that means, in so doing, making a good case for its sustainability and the ways in which it can bring positive gains for the local community and the local environment, the way in which it can fit into the best spatial strategy having regard to constraints, its deliverability, which is of essential importance, the opportunities it provides for net biodiversity gains and other sustainability enhancements and initiatives, and the potential to engage particular delivery vehicles for certain types of housing or employment proposals, having regard both to local and borough-wide needs. Now, in terms of delivery vehicles, I'm referring here to larger sites. They may be very, very large employment sites. They may be very, very large mixed use or housing sites. Because if, and I take here as an example, garden communities, which may be bigger than villages. They may be the equivalent of a new town, and I'm promoting a few of those at the moment. You've got to have regard to how this development is going to be delivered. And so it might well be that at a very early stage, one needs to consider whether or not there's a need for a special delivery vehicle. It could be in the form of corporation, a new town corporation. It might involve consideration of what kind of planning mechanisms are going to be used, planning at development management stage in terms of delivery to make delivery easier. And that could include, for example, the use of a local development order. All of these things matter because, as we'll see in a moment, deliverability is often a key issue in determining whether or not a site is going to make an appropriate contribution to the supply of either employment or housing within the planned period, and at what point in that planned period it's going to make that contribution. Next slide, please, Ashley. So the call for sites will come about. promoters need to make the site stand out. And you would have done that by promoting its attributes, justify its release by reference to likely spatial strategy, make the case for its likely viability. Now, this is important, particularly in relation to complex sites or sites that have constraints that could actually slow down delivery or actually make it difficult to deliver at all. Make the case for delivery. In other words, indicate, having regard to any constraints that may exist, how the site can be developed and what kind of interest there will be in developing it, what the market's response is likely to be to that site, how many developers would need to be on site to deliver if it's a very large site, etc. So all of that kind of information is very, very important at this stage. It would also, in that context, be appropriate to provide an indicative trajectory based on site-specific data and comparables. Now, most of us will have seen the industry comparables, NLP's work, for example. Now, that is useful as background, but it doesn't necessarily indicate how larger sites, for example, might deliver. And I know in many cases now, and certainly true down in Folkestone, that the anticipated delivery for its proposed new town is at its peak about 450 dwellings a year. But that is backed up by good evidence as to how the site can be delivered by using various delivery models, various products, and I'm talking here about different types of housing, and the way in which they can be brought together without imposing too much in the way of competition, which might otherwise impair the motivation of the developer to bring the site forward for development. It's also quite important to provide illustrative layouts to show how the site can be developed, how it can integrate with and provide enhanced transport infrastructure, maintain its long-term sustainability, and provide good access to services, and demonstrate how the development of the site will bring additional community and environmental benefits. All of this is extremely important early on, because the local planning authority will need to understand what kind of contribution the site can make, how dependent it might be upon the provision of external infrastructure, and what that means in terms of the ability of the local authority to allocate sufficient land to make sure that it can provide a 5- and 10-year supply in accordance with the MPPF. Okay, Ashley, if I may have the next slide, please. Site-specific constraints are matters which need to be addressed at the outset. How can they be managed? Are they particularly problematic? And can they be overcome with solutions that would be supported by statutory and other consultees? And I just pause here. One of the biggest issues during the examination process is making sure that highways authorities, and I include here also Highways England, the Natural England and local wildlife organisations in relation to the natural environment, the Environment Agency in relation to flood risk and contamination, and Historic England in relation to the historic environment. The last thing a promoter or indeed a local authority needs at examination stage is still to have issues with these bodies. So it's essential, so far as it's possible, to iron out differences with them as early as possible. Now, I know that in terms of strategic highways infrastructure, it can often be very problematic in dealing with the Highways Agency, sorry, Highways England, in the sense that they will have their own modelling, and their own modelling protocols may not coincide with those being used by a promoter or the local planning authority. So it's essential that both Highways England and the local authority and promoters are engaged in constructive dialogue from as early on in the process as possible. And that goes for other authorities as well. The proposed allocation. Well, if you are lucky enough to be a proposed allocation, you need still to seek to assist the local authority with policy wording in relation to the allocation, to avoid disagreement on effectiveness of the policy at the examination. And complex and major allocations may need a bespoke approach that has to safeguard interests, but also be realistic about phasing of development and supporting infrastructure. Next slide, if I may, please. So the promoter will need to provide strong support to the local authority at examination stage, because PINs will investigate the sustainability credentials of the strategy and those of the individual sites that make it up, assist in answers to MIQs and topic papers so far as relevant to the proposed allocation, and provide firm evidence about the deliverability of the site and its viability, having regard to affordable housing requirements, on and off-site infrastructure requirements, and other likely contributions. Be realistic about lead-in time to first delivery and likely annual yield over the lifetime of the development, and provide info on how on and off-site infrastructure can be phased and, of course, funded, and be ready to provide evidence to the examination to support the local authority's assumptions about the site and its delivery. Ashley, if I may have the next phase, the next slide. Now, this is a matter which is extremely important for local authorities, and it's a subject in its own right. But for both sides, the effectiveness of the policies, particularly those which are promoting sites, i.e. site allocation policies, the policy requirements must be evidence-based and justified. Drafting must be precise and capable of practical engagement and application at development management stage. There should be no wish lists facilitating or encourages in policies. They should require compliance with their terms, and they should be specific and unambiguous. And there should be no duplication of requirements, especially in site-specific allocations, unless those requirements are bespoke. So, for example, there's no need to include an affordable housing requirement in the policy, site allocation policy, if it's being provided in a generic policy, unless there is an exception to the amount to be delivered in relation to the specific site. And site-specific policies should, where possible, deal effectively with phasing requirements and delivery of key infrastructure at critical stages. So the input of the promoter is especially important from that point of view. So that's my overview for the purposes of this seminar in looking at the promotion of sites through the local plan process. I now hand over to Ashley.
Thank you very much, Paul. And I propose now to look at things from the other side of the coin, from the local authority promoting its plan. I'm going to do this chronologically. So I'm going to start with before you submit the plan. And the first two things I want to emphasize are invest the time and think about the evidence base critically. Read the objections that come in at Regulation 18 and 19 stage, especially those which criticize the methodology of the evidence base. Ask and challenge the consultants who have put forward your evidence-based documents or your own colleagues to think about the methodology they've chosen. Particularly important, to think about whether that methodology has been approved or adopted by another inspector examining another plan. Thinking, for example, about green belt methodologies where that's relevant. There's no standardized method for assessing green belts and assessing the sites which are most promising to release from green belts, but there are accepted practices and methodologies which have been approved quite consistently throughout other local plan examinations. So think about it critically, challenge your consultants or colleagues who've put the evidence base together and ask them to think specifically about the methodology they've chosen. The next thing that Wayne is going to develop after me in greater detail with reference to the duty to cooperate is do this together with your neighbours. Very many issues are cross-boundary. Very many issues can be dealt with much better at a sub-regional level. And it is also a very good way of assisting to show that you have discharged the duty to cooperate if you have, for example, worked together with neighbours in producing a cross-boundary air quality study. So think about working with neighbours in the production of your evidence base. And then I've said have an eye on reasonable emission sites. Well, we know that the relevance of emission sites officially is not especially important in an examination. We know that the principal purpose of the local plan examination is to assess the soundness of the submitted plan. However, we all also know from experience that especially in the preliminary sessions looking at the sustainability appraisal and the overarching spatial strategy, that alternatives can become relevant when the inspectors are asking themselves the policy question, whether the plan is the most appropriate strategy judged against the reasonable alternatives. And of course, when they're asking themselves the legal question about whether the environment report submitted for the purposes of Section 19 of the Planning Upholstery Purchase Act and the environmental assessment regulations has met the requirement to assess reasonable alternatives. So think about the choice of alternatives that you had to assess the spatial strategy against, and think about making sure that the outline reasons for rejecting the others are in the top of your mind. And I think the overarching question before you submit the plan is to ask yourself, does the strategy that you've settled upon, the plan you've settled upon, does it follow logically from the evidence base that you've assembled? And it's amazing how often perhaps that isn't asked before a plan is submitted. And I would strongly commend that to be done by stepping back and asking the critical question, whether it naturally follows. So before submission, and now after submission, but at the examination. Well, as Paul said, and I absolutely endorse what he said, that working with promoters is a way of making your life as the planning authority an awful lot easier, and making your task of promoting your plan more straightforward. But some particular things to think about. Firstly, topic papers. A number of issues at a local plan examination really cut across a number of the questions that the inspectors will ask. For example, housing needs will cut across a number of policy questions. If you're a greenbelt authority or you've got areas of outstanding natural beauty where you're promoting major development, it would be a sensible idea to have a topic paper showing how you've met that policy test of exceptional circumstances for either altering the greenbelt boundary or for major development in an AONB. And so bespoke topic papers can be a useful way of drawing together a number of different evidence-based documents in a summary form and making life easy for the inspectors to show how you have met whatever the relevant policy test might be. Secondly, statements of common ground, as Paul mentioned, can be very helpful in showing how a site can be delivered. And by that I mean statements of common ground with promoters, statements of common ground with the various consultees, Highway Authority, Natural England, Historic England, etc., to make sure that their position is clear and that they are aligned with the plan that you are promoting. And the issue really is the critical question at examination often is whether the proposals as submitted and the strategy as a whole is deliverable. And within that are questions related to the trajectory. Is that, for example, realistic? Is it realistic to expect delivery of housing on a site within a 5-year period where much of that site isn't in the land ownership, for example, of the promoter, or if it relies on significant off-site highway works to make it acceptable? If you've got a situation like that, a statement of common ground can be a good way of showing how those obvious questions, which might bear on the delivery of the trajectory, can be resolved. For example, you might not own the site, but the promoter has a promotion agreement which provides for the swift transfer of ownership within a set period of time after the site is allocated. And an important procedural point is to make sure that you ask the examining inspectors to propose main modifications if they find them necessary. I can't think of a single local plan which has been adopted without any main modifications at all. And remember that under the Act, the inspector has no power to consider main modifications unless that they are asked for. So always sensible to ask for that, but you'll probably get a prompt from the inspector if you haven't. So at the, you've been through the examination, you've come out the other side, and this might be a tempting point to perhaps relax a little bit and take your foot off the accelerator. But perhaps because of that, this is the period of time when, in my experience, there are the most likely legal errors made. And that's often because there isn't a revisiting of the sustainability appraisal with a sufficiently open mind to address main modifications that may well have arisen from the examination, or that the reconsultation on those modifications isn't in line with a statement of community involvement, for example, or some other legal error. So this is a time after the examination, you've got that interim letter from the inspector setting out a number of points to do before the plan can be found sound. Do make sure you revisit your evidence base and especially the sustainability appraisal and make sure that it's done with an open mind, and you reassess the reasonable alternatives properly, and that you do ensure that the consultation is done correctly. And then the final point where there is a potential for problems is at adoption. And you might think you're really on the finishing line at this point, but there are risks here to be aware of. We know that adoption must be by the full council, so make sure it's not done by a subcommittee. And we know that the power to adopt the plan these days, certainly post the 2004 Act, is tightly controlled. You can, if there have been modifications that the inspector has found necessary to make the plan sound, you don't have any choice but to accept those, or to start the process again, or exceptionally to try and ask the Secretary of State to use his powers under section 22(4) to direct that he decide whether to adopt the plan or not, whether to use his intervention powers. So make sure that's done properly. And remember, of course, that adoption is itself subject to legal challenge. The decision to adopt is subject to a judicial review. For example, South Oxfordshire's decision to adopt its plan subject to a judicial review at the moment, before the statutory challenge period kicks in on the formal notice of adoption. And that really turns on whether the council have been given the appropriate advice in the officer's report, whether the documents were properly available, all the things that you would normally do in advance of adopting an important policy document, make sure that you do, and make sure that you set out the options clearly, but also neutrally for councillors within an officer's report. Incidentally, one of the allegations in the South Oxfordshire Judicial Review is that councillors were improperly influenced by the threat of not adoption, it is said, although that challenge is so far not been granted permission to proceed. But it does just illustrate that even when you get right to the finishing post, there are legal risks which you want to make sure you get nowhere near to stop you adopting the plan. So with that, I'll now hand over to Wayne, who will tell you about duty to cooperate.
Thanks, Ashley, and good afternoon, everyone. If we can move straight on to the first slide, please, Ashley. So my talk this afternoon is focusing on the duty to cooperate in particular and looking primarily from a local planning authority perspective about what our top tips are to try and ensure success at the examination stage in relation to this issue in particular. And as the slide indicates, one of the reasons why this is a critical issue for local planning authorities to assess is that failure in relation to the duty to cooperate will inevitably mean that the plan has to go back a number of stages. And if a fair amount of time has been taken getting the plan as far as the examination stage, then the likelihood is that the evidence base will have moved on quite significantly by the time of any inspector's letter or final report declaring that there's been a failure to comply with the duty to cooperate, meaning that elements, perhaps important elements of the evidence base, will need to be reassembled, reconsulted on before a further iteration of the local plan can be submitted. So for those reasons, it's important to do four things in particular in relation to duty to cooperate at an early stage. The first is to identify it as being a high risk area for the examination process, and so to prioritise it accordingly in relation to that. The second is to bear in mind that inspectors, like judges, come from different parts of the spectrum when it comes to the duty to cooperate, and they apply, it is quite clear from some of the final reports, a varying standard to that question. And so the best approach is to assume that you're going to have an inspector who looks at the duty to cooperate as being one of the fundamentals of the plan, from which a number of critical issues like spatial strategy and the distribution of development will proceed. Quite often you may be fortunate and have an inspector who, for example, is really only concerned about duty to cooperate compliance where serious issues are being raised by statutory consultees. Some inspectors, as we know, take a relatively generous view to looking at whether or not there's been compliance with the duty to cooperate across the board. Other inspectors will focus on one issue, and typically in recent cases, with one notable exception aside, the Wealden example, that has been to do with unmet housing needs being met, whether it's within the authority area or an authority that needs to export, not having its needs sufficiently considered in the inspector's view by the potential importing authority. And part of the difficulty that faces local planning authorities now is that there's some support in the case law for the idea that failure on one big ticket, as it were, but single issue, can be enough to fail the process entirely. In the St Albans case and Sevenoaks are some authority for that proposition. The third thing to bear in mind, again, in looking at the level of priority that you accord to the duty to cooperate, is that it's one of those issues that is very difficult to challenge either way, in fact, once an inspector has made a decision about it, because the courts have repeatedly recognised, without fail, in the case law, that it's a question of planning judgment to be decided by the inspectors, albeit the Sevenoaks case does give some helpful guidance about the margin of appreciation that should be accorded to the local planning authority's decision making about the duty to cooperate, even by inspectors as well as by the High Court. So that's the third point to bear in mind. And the fourth point, and one that the new guidance in the 2019 MPPF really brings to the fore, is the importance of the audit trail, and that needs to be clear, robust and comprehensive from the start of the process in order to ensure that there is, as it were, a relatively ready way of demonstrating that the requirements of the duty have been met. So as we move on to the next slide, we remind ourselves of what those requirements are. And they are the mandatory nature of the duty to cooperate in maximising effectiveness and in a way that is done constructively, actively, and on an ongoing basis. And that's a formulation that people watching will be familiar with seeing in inspectors' reports, and indeed specifically commended in a number of judgments that have dealt with the duty to cooperate issue. Often those three elements, and they are three separate elements of compliance with the duty. So there is a need to demonstrate by the audit trail that all three of those elements have been met. It's often dealt with stage by stage within the judgments of the High Court. So it's those three elements of the duty that need to be both pursued by local planning authorities and supported sometimes by site promoters who have allocated sites, as well as being documented. And the way that it needs to be documented within the materials that the local planning authority is publishing for the purposes of the submission version of the plan is with a clear focus that relates to the outcomes of the cooperation, because it's always very useful to have information about cooperation at earlier stages, for example, in the assembling of the evidence base using joint parameters, joint studies, and so on. But there is no doubt that what inspectors focus on during the examination process is the extent to which that useful cooperation has led to concrete outcomes. And so the fifth top tip that I would give in relation to the way that the duty to cooperate should be approached is all of that is a very useful way to begin the duty to cooperate process. But do not assume as a local planning authority that just because you have reached agreement with your neighbours, that will necessarily be sufficient for the inspector examining the plan. Again, for some inspectors, the idea that there has been agreement between authorities, and it's again easy to take the example of unmet housing need because it's the one that arises most frequently. A number of inspectors will be content that as long as there is agreement between the main parties who actually need to shoulder the burden of meeting the need, then in fact the duty to cooperate is met. And if there are any other deficiencies in the inspector's eyes about how that issue is to be addressed, then that becomes a matter of soundness. But that is not invariably the position. There are examples where inspectors have seen that parties have agreed a position, but that agreed position has not resulted or would be unlikely to result in effective delivery of what is required across the planned period. So in this example, again, the provision of sufficient levels of housing across the whole of the housing market area. So it's important to be clear about what the agreement that you've reached with other authorities will actually result in. If we move on to the next slide, please, Ashley. That contains the list in particular of prescribed bodies, and as the previous speakers have already said, any authority submitting its plan for examination wants to find itself in the position where, at least in relation to the methodologies that are being used in the evidence base that's been assembled by the local authority, that the statutory consultees are on board with that approach and that they are on board with any of the more strategic allocations that are being proposed within the plan. There may be examples where statutory consultees still have reservations about particular policies that are applying to individual allocations or individual parts of development management assessment. That won't cause a particular difficulty normally as far as the duty to cooperate is concerned, but it is important to have that in principle level of agreement with your statutory consultees. And if that level of agreement can't be arrived at, then the importance of the audit trail is in demonstrating where there is disagreement, why there is disagreement, and explaining clearly what the authority's position is in relation to the reason why that issue couldn't be resolved. And so in terms of tips for moving the examination process forward smoothly, the sixth point that I would make is that it's critical to have in place a system that ensures that duty to cooperate discussions take place with specific regard to three matters. Firstly, that they need to happen at regular intervals, as well as at the key stages in plan making, so at Regulation 18, Regulation 19 stage, but also in between those two stages as the evidence base is evolving in what may be very important ways to dictating the overall spatial strategy of the plan. And that approach is now explicitly reflected in the provision of statements of common ground of the 2019 PPG. And PPG is really quite helpful in terms of the level of detail that it sets out in how to approach those documents. The second point is that the discussions need to take place with all necessary stakeholders ranging across the board. Very important to make sure that no key stakeholder is omitted from the process. And then thirdly, as we heard earlier, duty to cooperate is only engaged in relation to strategic matters that are capable of having significant impact across more than one local planning authority area. But when you're trying to decide what is or is not a strategic matter, then the counsel of prudence is to err on the side of caution, so that those matters that may, in the inspector's view, turn out to be strategic matters are fully covered by the duty to cooperate discussions. And so moving on to the next slide, please, Ashley. What I've sought to do here is just lay out the key strategic matters that come up time and again through the examination process, together with a reminder of the definition of what constitutes a strategic matter. But the seventh key point that I would make going through this process is that many of the points that are raised here, if we look at that list, spatial strategy, housing, greenbelt, and matters of significant infrastructure, those points often raise politically sensitive and difficult issues. And the point in relation to the duty to cooperate is that it's important in demonstrating the audit trail not to shy away, as tempting as that may be, from those points. A level of early engagement is important, and if anyone needed a reinforcement in relation to that, then simply looking at the Sevenoaks decision will give some clear indicators there. So in terms of compliance with the duty to cooperate, it is much better to try and reach agreement with your neighbours on these politically sensitive issues and to fail than to not have grappled with a difficult issue. And one of the ways that the new PPG 2019 suggests this might be overcome is by the use of facilitators or arbiters in relation to those politically sensitive issues. So again, quite often the guidance refers to the need to consider certain things, and that's something that should be considered in appropriate cases, as well as the idea of potentially joint plans, and even where there aren't joint plans, potentially joint individual strategies or strategic policies dealing with areas that have clear cross-boundary ramifications. Bear in mind, as another tip going into the duty to cooperate approach, that whilst there is a line of authorities coming from Bark and Miller states, that there is sometimes almost no point in asking the question if a local planning authority can know fairly precisely and accurately what its neighbour will say. In fact, inspectors by and large have been unsympathetic to that as a response from a local planning authority. So it is much better to specifically ask the question and receive the answer, even if it's in the negative, because then you will know as the plan making authority how far you need to pursue that matter before you've got sufficient evidence to put before an inspector to say, look, we've done everything that we sensibly could here, but we can't secure agreement on that issue. So if we move on to the next slide, and what I've done there is just to draw some brief distinctions between the earlier approach in the 2012 MPPF and the new approach in the 2019 MPPF, with the paragraph references given. And what has happened is the key change to a slightly more prescriptive approach set out both in the MPPF and more particularly in the PPG about how to go about demonstrating compliance with the duty to cooperate. But one of the themes, and the next key point to note, that comes out from the national guidance is the idea that this process should be carrying on throughout the plan making process. So whether or not the courts have given some observations that duty to cooperate may only really apply to the Regulation 19 process, by far the safest approach is to ensure that you are throughout the plan making process from Regulation 18, potentially earlier than that, dealing with these kinds of issues and how they can inform the deliverability of the plan. Look at the detailed guidance in the PPG and what the statements of common ground are expected to contain, and you'll see a focus in early consultation and also a clear focus in taking steps that meet housing need for an area. That is something that is repeatedly a point of focus within national guidance. And so if we move on to the next slide, please. What I've done there is just listed the main cases. I'm already running short on time, so I've just set out some mnemonics there, which tend to make it easier to remember some of the key cases. I've listed most of them, but of course there's also St Albans case number 2 and Wealden as well to look at. But the Sevenoaks case as a recent case is useful in its discussion both of how neighbouring local planning authorities should be engaging with one another, and that important point about the margin of appreciation that should be accorded to a local planning authority's decision making when it comes to the duty to cooperate. Next slide, please. So whilst the duty to cooperate is not a duty to agree, it is in practical terms a duty to explain why agreement could not be reached in those circumstances where it can't be. And as I've indicated, don't necessarily stop at agreement either. There may be circumstances in which it is in fact necessary to go further, but where it hasn't been possible to agree, there does need to be a comprehensive and robust evidence base demonstrating that point. That's a phrase that's used, again, repeatedly through the authorities. So another 2 top tips sort of resulting from what's on this slide. The first point is that involvement at member level remains critical when key decisions fall to be taken. But it's also important within the evidence base to be able to illustrate member involvement internally as matters take shape over time, so that when the opportunities for external discussion do arise, they take place against a fully evidenced position, allowing clear decisions to be made and recorded based on justified and substantial evidence. And the assembling of, it sounds straightforward and obvious, but it's a point worth making, that sufficient evidence should always be preceding the decisions that are being made in the local planning context, albeit there may be further justification of decisions after the event, depending on what objections are made to the decisions that have been made. And related to that, another important point is to ensure that any areas of disagreement are bottomed out as far as possible, so that it's clear to the examining inspector what has been done in that respect and how hopefully narrow ultimately the areas of disagreement are. So moving on to the next slide, what I've done is set out some of the headlines from the report, and they can really be taken from the slide as you read it. But again, as I indicated earlier, what's interesting about the focus of these cases running now over a period of about 6 years in the authorities is that if you strip the Wealden case out, they are all either significantly or entirely about unmet housing needs in the relevant areas. So in terms of where to focus your duty to cooperate efforts, if you suspect that there are issues in relation to how housing needs are going to be met either by your authority or by other authorities within or just abounding the relevant housing market area, then that is something which the cases emphasise needs to be robustly considered. And that comes back to the point about political sensitivity that I raised earlier, and finding appropriate mechanisms to ensure that those matters are fully ventilated. So again, in terms of tips for success, the tip here is to ensure that there is particularly clear and sufficient material addressing the issue of housing needs, why any need, for example, can justifiably be exported, or the nature and extent to which a local planning authority can or cannot accept imported housing need. Then moving on to the next slide. Again, in considering the duty to cooperate, bear in mind, it's always, at the end of the day, looking to deliverability of plan policies, whether or not the engagement has been constructive, ongoing and active, and how has it shaped the plan policy. So it's important for a local planning authority to have a narrative as to how the decisions that have been made in that respect have been important in serving to shape plan policies that bring forward a spatial strategy that will work for the period of the plan. Next slide, please. Just there, a statement of what outcomes can include, so that an authority doesn't miss, as it were, any of the important elements of duty to cooperate that can be perfectly properly relied upon in demonstrating that it has complied with the duty over the local plan as a whole. And then the final slide, I think, oh no, two more. Importance of audit, I've referred to, it's in as an early top tip. I come back to it as being the central message within success in the duty to cooperate. It's really difficult to overstate the importance of being able to produce that flowing narrative over the appropriate points of the chronology to the inspector. And bear in mind that whilst the 2019 MPPF and MPPG guidance refers to the use of statements of common ground, it will be important quite often to have the primary evidence available that supports the statements that are made in those statements of common ground, in case any of those statements become controversial during the course of the examination. So it's important that the library of primary documentation relating to duty to cooperate is kept from an early stage and kept up to date. And now the final slide. So just in terms of the future, after a few years where the planning scene was relatively quiet in terms of the duty to cooperate, it's become more of a feature over the last couple of years again, and the implications of a failure to comply with the duty are now well known and unfortunate. And it is an irony of the system that in circumstances where the duty to cooperate has been failed, it has more often than not been in areas with high housing pressure, where as a consequence of the failure, little progress will be made in relation to the supply of housing. In circumstances where if the plans have been, as it were, allowed to proceed, then greater progress might have been made in the short and medium term. In terms of future options, is obviously a live discussion at the moment about what form the duty to cooperate should take in the future, whether it should survive. But it's clear from the commentary that is routinely in the planning press at the moment that there is a need for some kind of strategic approach to plan making. And in the absence of the duty to cooperate, one wonders whether or not simply having voluntary joint arrangements between authorities will be enough. So I suspect as time moves on that either there will be some form of replacement for the duty to cooperate, or we will need to see a greater move back to a more formalised process for having a level of strategic plan making. But we wait to see what the future, perhaps the relatively near future, brings. Thank you very much. Thank you, Ashley.
Hopefully Claire is able to engage
Yes.
on the screen.
Can you see me?
We can.
Excellent. I can't see myself, but I'm sure that's probably a good thing. So I think I've now got only a couple of minutes to tell you something about legal challenges to local plans. If I could have the next slide, please. So I've only got two topics I'm going to look at quite briefly today. First of all, when can you bring a challenge? And secondly, what is the basis of a challenge? So if I could have the next slide, please. The question of when is a tale of three cases, and those three cases really turn on a part of section 113 of the 2004 Act, which says, other than as set out in section 113 itself, a relevant document must not be questioned in any legal proceedings except insofar as provided by the following provisions of this section. So that essentially provides an ouster clause, and three cases have looked at the question of when that ouster clause applies. First of all, the case of Manydown, and this concerned the Basingstoke and Deane local plan that you see on the slide, and specifically it was a challenge to a pre-submission draft core strategy, which didn't include the Manydown site, and the Manydown claimed that that was an unlawful decision. Of relevance to this is that the council tried to defend their position by arguing that the proceedings for the judicial review were barred by section 1132, the provision I've just read out. And the court didn't accept that. The court pointed out that as it was an ouster clause, it had to be strictly interpreted, not an oyster clause. That would be a rather more delicious thing. The previous wording had been whether before or after the plan has been adopted, approved or adopted. So section 113 had changed the position, and in the circumstances, section 113(2) didn't oust the ability to challenge by judicial review the pre-submission draft plan. And the court also accepted that that they went on to found that the council's decision was unlawful, and they accepted that they shouldn't withhold the remedy. They accepted that it wasn't sufficient to say that the claimant could argue for the site's inclusion in the plan through an admission sites process. And just if you go on to the next slide, this process did lead to ultimately an allocation in the local plan, and in July 2020, don't say planning doesn't move slowly, resolution to grant planning permission for a development of up to 3,200 homes was made by the council, and I don't think there actually is a planning permission in place so far, but from a challenge all the way back in 2011, there's now a resolution to grant the scheme that you can see on the slide in front of you. So that is pre-submission plans. If we move forwards onto the next slide, we can go on to the case of CK Properties, and we are now moving forwards to a challenge to the lawfulness of the decision to publish a submission version, a Regulation 19 version of the Epping Forest District Local Plan. And this was a site that the claimant wanted to promote for 133 houses. That was originally included in the plan, but had been excluded due to impact on Epping Forest. And that's a lovely picture of Epping Forest, looking rather beautiful, that you can see on the slide. And again, the council sought to argue that the claim was ousted by section 113. And again, the court rejected that. They said that, in fact, only a challenge to an adopted local plan is precluded by section 113. And prior to that, one could still bring a challenge by judicial review. However, that claim actually failed on its merits, and the plan process is still winding its way through, as far as I can see, without that site in it. So that takes us to the third in our trilogy of cases, IM Properties, a case involving Lichfield Cathedral, looking rather beautiful on the left-hand side. And this is now at a challenge to a decision to endorse main modification. So we're the next stage through the process again. And the process was that the council had put forward a plan. The inspector had identified that there was a need for further housing sites, and the council had, through a main modifications process, decided to release 2 areas of land from the green belt, and the claimants were promoting land to the northeast of Lichfield that wasn't in the green belt and took objection to this decision. However, unlike in the other 2 cases, the court did find that the challenge was precluded by section 113, and the court saying it's precisely because of the potential chaos that could be caused by a successful challenge at this stage in the plan making process that, in my judgment, Parliament inserted the ouster into the statutory provision. So the court in that case seemed to think that the ouster could apply prior to the final adoption of a plan. So we know on authority it doesn't apply to Regulation 19. You can challenge the issuing of a Regulation 19 document, and there is some question in between the authorities as to whether you can challenge the main modifications, but certainly the court seemed to think that by the time one gets to main modifications, you should wait and challenge the substance of the plan. It should be said in this case, the claimant also challenged on the substance of the plan around the correct approach to greenbelt release. They failed in that. They failed in their challenge to get the plan, an injunction to get the application of the plan withheld while their planning application was heard. Their planning inspector recommended refusal of planning permission, but in spite of all of that, the Secretary of State finally granted them planning permission, and it seems as though they are due to start producing housing. So there you go. The success or otherwise of a challenge under to the legality of a local plan doesn't necessarily determine whether you will ultimately get planning permission. So that's when, of course, there's no question that you can challenge on adoption of the plan. There's some strict time limits set out in the in section 113, and the case of Wealden versus Lewis and South Downs explores some of the applications of those time limits where you've got 2 local authorities adopting a plan in succession. So in terms of timing, definitely once the plan's adopted, questionably not when the main modifications are coming forwards, and prior to main modification it seems you can challenge, but that has to be by judicial review. So what can you challenge on? If I could have the next slide, please. The challenge under section 113 is a judicial review type challenge, so it has to be brought on grounds of an error of law, not simply a disagreement with the conclusion reached by the local plan inspector or by the council on adoption. And if one looks through the cases, these sorts of challenges are actually relatively rare, and these sorts of challenges succeeding are even rarer. On a rough sort of estimate, around in the last decade, there's been around 41 substantive challenges, of which only 15 have been successful. So it is only remains relatively difficult to challenge a plan. And in particular, what is clear from the cases is that the courts have generally given a fairly wide margin of appreciation to inspectors in respect of judgmental areas such as soundness. However, there are some areas where claimants have enjoyed more success than in other areas. The particular areas where claimants have enjoyed relatively large amounts of success, the question of SEA and reasonable alternatives, particularly towards the early part of the last decade, there were quite a number of cases exploring the extent to which a council was obliged to look at reasonable alternatives as part of the SEA process. A calculation of housing needs has been various. We've been through various iterations of the NPPF and various iterations of how one calculates housing need. Some claimants have been successful in showing that the approach taken by the local authority is unlawful, and green belt issues have come up in a lot of these cases, but have enjoyed very mixed success. Wayne's already discussed to some extent duty to cooperate with you. Not sure whether Wayne specifically made this point, but so far we haven't had any successful claims under duty to cooperate, and other sort of individual particular points such as consistency with other plans and habitats regulations assessments have come up from time to time. So those are broadly the sorts of topics which have enjoyed success. And if you are here for a local planning authority and you're worried that after all your hard work, your plan may be quashed, it is worth pointing out that not only have there been relatively few successful claims under Section 113, but also even if a challenge does succeed, the court does have very wide powers to decide how to proceed. So it doesn't necessarily mean that the plan as a whole will be quashed, or even necessarily that one policy will be quashed. The court can remit the matter to an inspector with directions as to how to proceed. And as one goes through the cases, one can see that the courts are willing to use those alternative methods. So it doesn't necessarily follow, even if you can demonstrate an error of law, that the whole plan or even the relevant policy will necessarily be quashed. So that's, I'm afraid, slightly whistle-stop tour of legal challenges to local plans.
Thank you very much, Claire. That's great. And thank you also, Wayne and Ashley. We have one question only, and that comes from Jeremy Baker. And Jeremy says, although I think Dr. Bowes read out the old MPPF test for DPDs, the most appropriate strategy, the latest MPPF only requires an appropriate strategy. What difference has this change made, if any? And I'm going to invite Ashley to deal with that question.
Thank you, Paul, and thank you, Jeremy, for the question. That's quite right, that the new framework in 2019 changed the wording for what the government considers a sound plan from the most appropriate strategy judged against the reasonable alternatives to an appropriate strategy taking account of reasonable alternatives. That change was deliberate and followed the consultation that suggested that people might well get hung up on whether it was the most appropriate strategy when it may be an appropriate one. But nevertheless, there's still a requirement to have regard to reasonable alternatives, and therefore the requirement to suggest why you've adopted the strategy against other options is still there. And so it's still important to assess the other options and why you rejected them in preparation for the examination. Thank you for the question.
Thank you very much. Jeremy Pine has asked, in relation to the duty to cooperate audit, how detailed should annual statements be? Again, Ashley, is that a matter for you?
It might be Wayne.
Or Wayne, I should say. I'm so sorry.
All right, Paul, thank you. I'll have a crack at that one. Jeremy, thank you for the question. It's a contextual matter, as it seems to me. Experience shows, and this is where I say it's always helpful when the annual statements are being drawn up to go back to the PPG guidance, because over about 14 paragraphs or so, it's quite prescriptive about the approach to what can usefully be contained within the statements. But the key is to enable, if we go back to the topic of unmet housing need, then the key will be to have sufficient information which shows the main points. The guidance is quite clear that you don't have to record every meeting that takes place or the nature of the discussion from every meeting, but what does need to be recorded in the annual statement are the main items that demonstrate a level of progress since the last statement was compiled, or if there hasn't been a significant level of progress, then it would be useful for the statement to explain why that has been the position. It may be that because of the plan making status of plan making place that the other authorities that you're seeking to cooperate in have found themselves. They're just assembling evidence. They're not necessarily in a position to make firm decisions about things. Then that needs to be recorded within the annual statement. So the importance of the annual statements is that over time, they provide a sequence that inspectors can look at to satisfy themselves that there has been continuing progress across the whole of that chronology. And of course, there will be times where more progress will be made, and it may be necessary for the statements to be more detailed. But it is important to ensure that where there isn't an apparent level of progress being made, at least in relation to outcomes, whether that's because there has been progress in relation to agreeing the evidence base, what the parameters of that are, and so on. So all of those things can be recorded. I think the answer is that because the duty to cooperate is such a fundamental element to success at the local plan examination, that you should always record things as fully as appears sensible to you as the local planning authority, because an inspector is very unlikely to criticise an authority for putting too much information within the annual statement, whereas the consequences of potentially trying to be too concise could be very severe. So I would answer those annual statements very fully and taking on board the guidance that's in the PPG.
Thank you very much, Wayne. There are no more questions to answer. We've run over our time a little, but I hope everyone has found that a constructive and useful webinar. The webinar is available on our website, so for any of you who would like to revisit it, please do so. If you have any observations about the presentation and its content, please let us know what you think of it, and we would welcome your feedback. And on that note, all I would say is I wish you all very well, and thank you very much for attending. Thank you.